Good evening, everyone. I'm Saquib Rahman, Senior Lecturer at the Department of Law, North-South University, would like to welcome you all to our webinar today. It would be an absolute delight for us to be able to listen to Professor Gregory Shaffer, who has very kindly made the time to talk on emerging powers and the world trading system, the past and the future of international economic law. Before we request Professor Gregory Shaffer to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would extend my thanks on behalf of the Department of Law to all of you present here. Now, regarding our guest speaker, Gregory Shaffer is Chancellor's Professor of Law at the University of California, Irvine School of Law, and President-elect of the American Society of International Law. Professor Shaffer is a leading international trade expert, author, and consultant on the World Trade Organization, WTO, European Union law, globalization, transnational legal orders, and transnational legal ordering. He introduced the concepts of public-private partnerships and legal capacity in the WTO dispute settlement system, examining how they work in practice in the United States, the European Union, Brazil, India, and China. Professor Shaffer has written major books on the international law and politics governing genetically modified foods, transatlantic relations, and works in the tradition of legal realism and social legal studies. His publications include 9 books and over 100 articles and book chapters. And before we go to Professor Shaffer, I would like to request Professor Rizwanul, Chair of the Department of Law at North-South University, for his introductory remarks.
Thank you, Saquib. Good morning to Professor Shaffer, and I want once again like to thank him for making time to speak to our students and also the other members of the audience. It has been an absolute pleasure to read his recent work on the theme of today's talk. International trade law, in my view, is at a crossroad. The founders of the system, principally the US and also members of the European Union, they have somewhat retreated from their dogmatic faith in the international trade regime. For sure, the US was the principal architect of the GATT and then also of the WTO. But it would be fair to say that in the recent years, the US has shown some sort of disenchantment with the WTO regime. And the emerging powers, particularly the 3 countries that Professor Shaffer has focused on his book, India, China, and Brazil, they have mastered the system in a way that they have increased their legal capacity. They have defended their interest both through litigation, through the WTO DSB, and we would like to see how Professor Shaffer presents the future. In my understanding, the system is potential. All nations would somehow be better off under the WTO umbrella or something of an international regime. Would that regime be the current WTO? We don't know for sure. Would it be something else? We do not know. Would the current US government take any different approach from the Trump era, particularly Trump's nationalist agenda, or would we see something else? So these and the other questions, I'm sure Professor Shaffer would be presenting, and I'm sure it would be a very riveting talk. I look forward to that talk. I thank you all once again for your time.
Thank you very much, Professor Rizwan. Professor Shaffer, whenever you are comfortable, please. Professor Shaffer, I'm afraid you are in mute.
Unmute. Okay, that should work now. I'm going in a moment share a screen, but I thought I'd give a little bit of a background of the book and talks I've given about the issues raised, which is the book. The first book I wrote on the World Trade Organization was called Defending Interests, Public-Private Partnerships in WTO Litigation. And it was a study of how does the United States and how did the European Union organize themselves to bring cases and to defend themselves in WTO litigation. And it was quite fascinating was that, that the United States has a very active business lobbying organization with high-powered lawyers who would organize to bring cases to try to convince the United States Trade Representative Office to bring them. And in the process, they would do legal research, they would write draft legal briefs, and so they put a lot of legal firepower into bring not only bringing cases, but also into the interpretation of the meaning of WTO legal requirements. And if you study WTO law, as you know, they're very complex technical agreements, which require a lot of legal know-how. And they're also, many of the texts are ambiguous. And so the interpretation of these texts is quite important, which requires sustained engagement, both with the texts and with the jurisprudence that gradually evolved during the WTO era. In addition, I went to Brussels and Geneva and talked with European Union representatives. And one of the great quotes that I remembered, which is in that first book, was the European Union saying, the problem with us compared to the United States is that there's no reflex for the private sector to organize and work with private lawyers to help us bring cases. And so we need to lobby them to lobby us. We need this sort of to create public-private partnerships in WTO litigation. We need proactively to go to them, whereas in the US, if anything, the USTR at times would feel besieged with the US. Somebody needs to unmute. I don't know. Somebody is, okay. I can see on the screen. Anyway, that led to a natural question, which it was, how do developing countries stand a chance in this system? If the US and Europe have so much, not only do they have lawyers, sophisticated lawyers who dedicate 100% of their time within the government to understanding WTO texts and to not only litigating them formally, but also having knowledge so that when they engage in bilateral discussions or negotiations over disputes, they wield a persuasive authority. And that resulted in a long research project on developing countries in the WTO dispute settlement system, which resulted in this second book, Dispute Settlement at the WTO, the Developing Country Experience, which actually has a chapter on Bangladesh, and particularly regarding the case that it brought against India regarding batteries. And it was a great experience because it was the first time that a least developed country had actually stood up to what is now, I write, as emerging power in the new book. And so that brings us, and let me put this on, let's see, 1 second. Why is this not 1 second? Before, there we go. Reading view, excuse me. So before, move this, okay. So that's the background to this book, because while I was researching developing countries and the WTO dispute settlement system, the world changed. In particular, and you saw certain countries become relatively successful, starting with Brazil, which of course brought a famous cases against the United States and the European Union with respect to agricultural subsidies. India became quite involved, and then finally China. And with that, and then of course, what happens is that the United States then becomes wary of the very system that it creates, and ultimately has neutered its dispute settlement system by stalemating the selection process of the appellate body, so that we currently have no automatic binding third-party dispute settlement at the WTO when involving cases against the United States in particular. So the book's methodology, for those of you interested in methodology, it's certainly a book that focuses on law, but it builds from extended case studies of these three countries in relation to the trade system. And it is based on over 200 elite interviews. By elite, it just means that, you know, professionals who are engaged in the system as opposed to just everyday people. And it's combined with a survey which tries to address the development of legal capacity across all WTO members, which is published in the World Trade Review, descriptive statistics, participant observation. I had a stint, one of the first law professors to be able to be with it in the WTO for a number of months. And I wrote this, the chapters on India, Brazil, and China with people from those countries. So it's not just an outside observer from the United States, it's someone working very closely with local academics, Henry Gao in China, who's been very closely networked with the major participants in China. James Nadumpra in India, who now runs the Department of Commerce's think tank on international investment law, but has been central on trade issues. And Michelle Raton Sanchez Badin in Brazil, who similarly has been very central to networks and in training Brazilian professionals. And then, of course, a review of primary and secondary materials. So it's the study is longitudinal in the sense that I have actually been doing this for almost 20 years, going to Geneva every summer, talking with people, in many cases, talking to people more than once. It's cross-sectional in the sense that it's looking at three different countries with three different systems. And it's not just going to Geneva. I spent a lot of time in these countries, speaking to people in the ministries, in the private sector, private lawyers, the main media correspondents who focus on trade, and so forth. I worked with academics. And so this can be viewed as a term of art, para-ethnography, which I find really quite helpful in describing the technique I used, because I'm talking with professionals who know a lot about the system and are constantly having to make decisions. And it's a dynamic system. So they're also thinking about it. And so for me, a very successful interview would be to tap into this active thinking of trying to make sense of where the system's going based on where it's been, with people from different countries, in the public sector, in the private sector, in international organizations, in ministries, and so forth. And that's called a form of para-ethnography because it's not just an outside observer then sort of interviewing people. It's actually a form and a sense of conversations that involve an active joint thinking in terms of what is happening within the system. So the key is to the book, in a sense, is the paradox that Rizwan mentioned, which is the US was primary in creating the world trading system. I mean, obviously, it was negotiated amongst all GATT members in 1948 and then WTO members in 1995, but the US was the global power, obviously, after World War II in 1948, and after the end of the Cold War in 1995. And so it had a primary role in creating this system. And you have political scientists of different persuasion, but here's just one, John Eikenberry, who's at Princeton, referring to this sort of what's called the rules-based order as an American world order, which he called a liberal leviathan, which he also calls liberal hegemony, which some will find to be an oxymoron because hegemony means dominance and liberal refers to a more pluralist system. But his point is that the US created a rules-based system and subjected itself to these rules. And now, of course, the US has been unraveling this world trading system that it created. And so the question becomes what explains this? And then, of course, as Rizwan also intimated, where are we going? So narrative explanations. You have economic, political narratives regarding what's happening, which are dominant. And I give a complementary legal narrative. It's not a displacement of the economic and political narratives, but it is a complement to them. So if you look at just the economic narrative in terms of the first is graph shows purchasing power parity shifts, where the blue line is the United States, the green line is the three emerging powers combined, and the orange line is China. And you see that China alone in purchasing power parity surpassed the United States. The three vastly surpassed the United States. And so this, and then this beneath is with nominal GDP, which shows how the closing of the gap between China and the three with the United States. Some of this, the economic explanation of what took place where China now became the world trading power, is viewed under the lens of global supply chains. Famous economist in Geneva, Richard Baldwin, has written powerfully about this development, where you combined US, European know-how with labor in other countries, particularly China. And that drove more and more trade than coming out of China. But of course, at the same time, China learned there were technology transfers that took place, and it moved up the value chain. So even famously, it used to be talked about the Apple Watch, about the the value added made in China was tiny. But gradually, if you look, the same people who took the original statistics have shown that the value added has significantly increased over time. Okay. So then what's the complementary story of law? Here's the World Trade Organization on Lake Geneva. That's the book. Here's the book's central question. How has the international trade and broader economic legal order changed since the WTO's creation because of Brazil's, India's, and China's rise and the development of trade law capacity? This is a photograph of the Foreign Ministry of Brazil and Brasilia, Itamaraty. I break down that core question into three separate questions that the book addresses. First, how did Brazil, India, and China invest in trade law capacity to take on the United States and European Union at the WTO and to defend their interests? Second, in doing so, how did these emerging powers change internally? And this is a key question, right? Because what was the impact of the WTO? And part of the major role of the impact was that they had to change their institutions and the professionalization of trade law in order to take on the United States and Europe and defend their interests. And so there were major changes in these countries that this book documents. Third, what are the implications of these developments for the WTO and the broader transnational legal order for trade and economic governance? And so finally, this third question is the international law question. What are the implications for trade, international trade law. The first two questions are really internal, and it's the link between the international and the national. What did they do? How did they change themselves to be able to successfully defend their interests in the WTO? So this ties into a broader theory where I have a series of books playing this out, but I think this is the most empirically rich book that I've done on transnational legal order theory. So by transnational legal ordering, I refer to the processes through which legal norms are constructed, flow, settle, and unsettle transnationally across levels of social organization. So by legal norms, most law is sort of psychologists and sociologists. Much of law is not needed to be enforced. It simply becomes part of the way of doing things. The way norms settle is it's what lawyers give in terms of everyday advice of how to do things contractually, what you can do, what you can't do, and so forth. And the transnational aspect of this ties the international to the national. I mean, if international trade law is going to be successful, the norms need to flow and settle within countries around the world, such as the way customs officials operate, tariff rates to what they charge, the intellectual property. What does it take to grant a patent, to recognize a copyright or a trademark? Professions adopt. How do legal and academics teach? Training new professionals. And these are how norms flow from the international to the national levels. The result of these processes can give rise to one or more what I call transnational legal orders. The concept of a transnational legal order refers to a collection of formalized legal norms and associated organizations and actors that authoritatively order the understanding and practice of law across national jurisdictions. That would be obviously an ideal type. We know that, with even national law, there's lots of crime, law is not perfectly complied with. But to the extent that these norms of what is legal and what is not legal, they can settle, but they can also become unsettled. So part of what we're seeing with the US challenge on the appellate body, for example, is to delegitimize it, that somehow the norms that it says are the norms that are to be followed transnationally are incorrect and not legitimately determined. Now, to play in this system, this is the complementary legal story. It's not just about sort of trade flows, nor is it just about sort of rise of what we saw before in terms of GDP, which is a form of power, economic power. I wanted to focus on trade law capacity, which is central to the book. And if you think about trade law capacity, you can think about it as a form of infrastructure. Just as, so the Belt and Road Initiative of China, or for the new US investment in infrastructure, is central to the economies. So is trade law capacity central to being able to participate within the legal system. So I define trade law capacity broadly as the ability of a country, through harnessing resources, to use law to defend and advance its international and domestic trade and trade implicated policies. Trade law capacity represents a form of capital or power to advance interests in a contested transnational legal field, that of trade law. So the definition of what are the norms, they're often highly contested, especially where texts can be ambiguous. They represent compromises. And so this is a form of capital or power to advance one's interpretations of what the law is, whether, as well as, of course, in negotiations over the development of the law. The concept has equivalents in other disciplines, as it constitutes a form of power for political scientists who focus on power, and an incentive-driven investment for economists. I break down the different ways that trade law capacity matters. This is a picture at the WTO. You see a number of countries' cards. And here's 9 different ways. Okay. So it matters a lot more than just for formal litigation. And of course, I believe Bangladesh has only brought 1 claim. If I haven't relooked, but drafting and negotiation of international trade rules. If you're going to create modalities for negotiation, contest modalities for negotiation, to understand the consequences of different word choices, trade law capacity is very important. Second, to being a case, you first of all have to monitor foreign compliance with commitments. And monitoring takes person power. You can do it through foreign embassies, but also it's important to have it in the private sector. So the private sector can recognize this is a trade law violation. They can talk to their attorneys. Their attorneys then can reference the matter to the government. Of course, then there's finally the third, the bringing of complaints successfully in specific cases. WTO law is very, very complex. In total, including annexes, there's probably around 100,000 pages of WTO jurisprudence. So very few people are able to keep up with this and understand its developments. In terms of economic theory, this is important in terms of shaping the terms of trade affecting a country's social welfare. By terms of trade, I don't know if you teach terms of trade to the students, but terms of trade simply references how much you need to export in order to get a certain amount of imports. If a country raises its tariffs and it has a lot of power to affect the price that you charge, so that you reduce the price in order to retain competitiveness for your product and compensate for the effect of the tariff, that means that you are getting less money for your exports than you otherwise would. But of course, to the extent you don't have that same power of affecting trade by raising your tariffs because you're a small country, then your terms of trade are negatively affected. And many developing countries complain about adverse terms of trade effects for them. 5 is important, and I've intimated this, for shaping the interpretation, application, and social understanding of the, quote, law over time, shaping the meaning of obligations. The meaning of legal text is often highly contested. It involves contests over shaping that meaning, and legal capacity is central for these efforts. 6, most trade disputes involve bargaining in the shadow of the law, both as regards future negotiations and the strategic pursuit of settlement in discrete cases. So 1, you're in a much more powerful situation to settle a case if you have strong legal capacity, much more persuasive in negotiations. But second, as regards future negotiations, just to give an example, is often the United States will argue that the cases that it's lost, for example, on zeroing and anti-dumping, they'll say that, these interpretations have affected future negotiations. You think about Brazil successfully bringing the cotton case against the United States and the sugar case against the European Union. That had an impact on agricultural negotiations at the WTO. So there's always a link between litigation and negotiation. Protecting domestic policy space for developmental and regulatory initiatives. You need legal capacity in order to structure your regulatory initiatives in ways that are more resilient to legal challenge. And legal capacity can be very important for this. Warding off capture by protectionist sectors. So governments are always beset by protectionist interests. And this is a way for them to ward off capture. And so it's very important to thinking about WTO law, not just in terms of disputes between countries, but also contests within countries, and the authority that this gives to government to manage its own economic development, and legal capacity is central. Triggering spillover effects, this is very central in the book, such as catalyzing a greater role for a country's lawyers in international private law settings. So just to give a quote from Chinese lawyers, from SOEs who I interviewed, they say that the WTO completely changed the mentality of how we conduct business in terms of contracting, in terms of the role of law and dispute settlement. So 4 challenges in building trade law capacity. There's the challenge of internal legal capacity, just how much expertise, and of course, having an important law school such as the North-South Law University in Bangladesh is central for building internal legal capacity. China invested immensely in this. Michel Raton Sanchez worked for FGV, a private university in Brazil. James Nadumpa works for Jindal, teaches at Jindal, a private university in India. So you see major investments in developing internal legal capacity. There's the challenge of financial resources. India actually, even though it's a big country compared to Brazil and China, its government felt more financially strapped simply because of the number of impoverished people in India. The percentage per capita compared to China and Brazil create sort of other demands for resources. And so they had the smallest staff of the 3 emerging powers within the government. The challenge of political power, of course, this, especially smaller developing countries, face lots of challenges in actually using trade law. You talk to African countries who will say that, well, we're threatened that foreign aid will be withdrawn, or we're at least concerned that it might if we bring a case, or even if we join a case as a third party. And then the challenge of internal governance, corruption, and so forth. That have really effective trade law capacity, the government can't be captured. You have to have hardworking people who are fully engaged, and same with the private sector. Investing in trade law capacity, you get greater professionalization of the trade bureaucracy, coordination between different ministries, the development of new career paths within the government. And this, the book all traces. You get coverage in media, became very popular, sort of the WTO dispute settlement. I'd read about it every morning in the major papers in Brazil, for example, when I was there. You have changes in the academia, new courses. This is the winners of a moot court competition in Beijing. The judges for the moot court competition here were both members of the government and of the major private law firms who would use these moot court competitions to recruit new people. You have a greater role of lawyers in the trade, the development of a private bar expertise. You have changes in the private sector. You have new sort of in-house counsel. You see this in SOEs, for example, in China. You have new specialists. New think tanks are developed both by the government and by the private sector. And this is traced across all of these countries. And you develop then what I refer to as public-private partnerships between the government and these different other actors, including academics. So the argument then is, what does this mean for these countries? So many of the major critics of the WTO use the term neoliberalism, that the world is becoming a neoliberal world. And the book basically shows that it's a much more complex world than that. And if anything, these states remain developmental states, which is one of the complaints that the United States has about them. The international trade regime seeded incentives for institutional changes within states to develop trade law capacity. The state policy favored public-private partnerships simply because it was a much more effective and efficient way for the state to defend its interests, to have broader-based legal capacity and not legal capacity simply monopolized within the government, within one ministry of the government. So that you have then the embedding of public and private legal expertise regarding trade within these states, which enabled them to build state capacity to adapt, respond to, and potentially and recursively shape the transnational legal order for trade. In sum, transnational processes did not lead to the weakening of the state, but rather the strengthening of the state's capacity to play an active role internationally in the legal ordering of trade. US disenchantment, a double-edged shift in inequality. So one, with the rise of China, India, and Brazil, it helped shake up politics in the United States and Europe. On the one hand, the income of the working classes in the United States and Europe stagnated and job security became precarious. On the other hand, now it is others, Chinese in manufacturing, Indians in services, Brazilians in agriculture, who in many sectors have outcompeted Americans and Europeans, and whose systems thus must involve cheating. The book talks about how the trade legal order was shaped in 3 different ways. This is, this one of these photographs of the corridors of the Belt and Road Initiative of China. Of course, it's obviously much more complex than this, but just to give a sense. Legal capacity investments facilitated enhanced engagement in negotiations that, as of now, contributed to stalemate at the WTO as a negotiating forum. 2, it led to the potential demise of binding multilateral dispute settlement, at least through the appellate body as a World Trade Court, given the United States response. And 3, it led to fragmentation of trade law system into webs of regional and bilateral agreements, which is going to be central to the future of the transnational legal ordering of trade. It's going to become much more competitive, including in terms of what could be viewed as rival transnational legal orders. And we will see how they mesh going forward. As a result, we now have competing bilateral and regional initiatives for transnational legal ordering, which raises a question about trade law capacity going forward. Paradoxically, these countries' investment in legal capacity has helped catalyze potential collapse of the multilateral trading regime and its dispute settlement system. Raises the question, what then is the benefit of trade law capacity going forward? One, I think we'll see a changed logic, especially between the United States and China. You'll see much more a sense of the use of law in terms of technology or ammunition to engage in lawfare, complaining that one or the other either is violating the rules or violating the spirit of the rules, as opposed to the law as a public good. If you think about the law in terms of you have a neutral third-party dispute settlement body, to which even rival great powers, United States, China, and Russia, which never have brought cases against each other before the International Court of Justice, for this period of time, resolved disputes before a neutral third-party dispute settlement body, which was remarkable, and we will see whether or not that's possible going forward. It will see a move to plurilateral and regional initiatives, bilateral deals, unilateralism, and tit-for-tat responses. So the challenge is what role in the WTO in a more complex, what I call ecology of trade law. It's not just one centralized organization, but now it's a much more complex ecology of trade law, involving bilateralism, unilateralism, regionalism, and the WTO itself. Just from the interviews, it's clear that these countries, their lawyers remain quite active in terms of engagement in international investment law, regional trade law, and so forth. So what's the normative implications? What might be done? There's a risk of collapse of multilateralism, the rise of trading blocs. There's some tempering, but I think we need to do is there need to be some tempering of globalization to manage the interface of different economic systems. Some tempering in light of new security challenges, some tempering to protect internal social bargains, and possibly some adjustment of dispute settlement. But we can leave that for Q&A. I think my time is up. I just want to thank you so much. If you're interested in the book, it's available, including on Amazon, both in terms of ebooks as well as in terms of paperbacks. So thank you.
Thank you very much, Professor. Professor, we do have a lot of questions, and whenever you're ready, I'd like to convey each one of them to you. Okay, here's the first question. With the current state of play at the WTO, do you see a revival of the bilateral or regional trade agreements and WTO becoming less vibrant?
Yes, I think that's certainly the dynamic we're seeing that's going to play out. A lot of negotiated norm making is going to be taking, I mean, it already was taking place. If you think about actually NAFTA preceded the WTO, and NAFTA included services for the first time and intellectual property in the first time. So you always see, we've seen for a long time, this competitive legal ordering. But I think we'll see it even more so given the distrust and the competition between China and the United States. China has been very active. It's signed more investment agreements than any other country in the world besides Germany. It's very, of course, we now have the RCEP, and we're going to see ongoing investment in these types of negotiations, including by the United States. My hope is, the question is, what role to preserve for the WTO? And I have a new article forthcoming, which is called Managing the Interface of US-China Trade Relations, where I put forth a proposal to return to, so that the WTO really provides an umbrella for all of these other initiatives. But I'll go on. If you have lots of other questions, I'll continue.
Here's another one. Do you believe that smaller states could reap the benefits of investing in the legal and institutional capacity building, just as China, Brazil, and India have done?
Yeah, and so, you know, the unfortunate answer is legal capacity is linked to other forms of economic and political power. As I noted, the 4 challenges, you know, the smaller developing countries are, even if they develop legal capacity, are still going to be subject to greater leverage in their international relations, to the extent that they, for example, benefit from GSP benefits or foreign aid. But that doesn't mean that they shouldn't be thinking about, they'll be, the question is, you know, compared to what? They certainly can't wield it as compared to the way China, Brazil, and India have. But will they be better off developing legal capacity? Yes, I think so. I mean, it was, I think when Bangladesh brought the battery case against India, and India settled in favor of Bangladesh and let the batteries in, it did 2 things. One, it signaled that, you know, the law can be helpful for countries such as Bangladesh. But 2, it signaled to other potential participants in Bangladesh, you know, to that comparatively, the better off to have this sort of legal capacity. I mean, that's the paradox of law, right? Is law often reflects, you know, those who are the most powerful in pushing that the law is structured in ways that reflect the norms that they want. And so it's no surprise that after the WTO was created, the US did not have to change 3,000 laws and regulations, and China did. And other countries around the world had to change their laws and institutions to a much greater extent. But once law is created, especially where you have a third-party dispute settlement system, other countries can use the law against those who are more powerful. And that's the paradox of law. And the question then is, for each country, how to develop the legal capacity to try to use the law, because they're better off using the law than simply facing the full brunt of political power with no check.
Thank you very much. Professor, here's question 3. There has been somewhat a disproportionate focus on the WTO law impacting on national law. What about the other way around? Could you share your insights on how national law impacted WTO law?
Sure. So, I mean, the whole idea of transnational legal ordering is to show the recursive and reciprocal relationship between national and international law. So many, if you look, I mean, this is the challenge of, and the critique of, for many developing countries of WTO law is, what are the US negotiating objectives? Well, if you read them, that Congress sets for US negotiators in intellectual property, for example, they are that the international trade negotiations are to reflect current US law. Okay. And so the US, in a sense, you could say, is attempting to export its intellectual property norms to the international level so that they then can be downloaded as part of into national legal systems around the world. So they're first uploaded, the norms in a sense are uploaded into an international treaty and organization, and then downloaded around countries around the world. And clearly this happened with respect to the TRIPS agreement. And so there you can see other areas. If you think about import relief law, anti-dumping law, the timelines for WTO dispute settlement for bringing cases, many of these reflected the ways of conducting anti-dumping, countervailing duty investigations in national systems, which were then exported into an international treaty, and then become the guidelines for what other countries around the world can do when they create their own systems. And so, yes, it's a reciprocal. What a Brazilian negotiator told me, what's going on, this is during the Trump administration, how do we interpret what the United States is now doing? And his position was that, well, the United States is basically trying to rewrite the rules. It doesn't think the rules are now working for it vis-a-vis China. And so it's using sort of the stalemate to basically rewrite the rules so that China's sort of way of organizing its economy has to be more like the US system. So it has to discipline its SOEs, it needs greater disciplines over subsidies and so forth, and that WTO is not sufficient. And so this would be another example, sort of recursively, now given the developments in the WTO system, sort of a push to reshape that system with new rules. And that's what's playing out before us.
Thank you very much, Professor. This question comes from the chair of the Department of Law, Professor Rizwanul. Would you view the emerging economic powers as reductionist or revisionist powers in the international trade regime?
So, so my argument in the book is that actually the revisionist power has been the United States, not these countries. Of course, you see the opposite rhetoric being used, but it's quite remarkable, I think, in times of these countries. If you go back to the new international economic order that China, India, other, developing countries, what they were pushing for in the 1970s. Certainly, it was sovereignty was central to that. And they're very concerned about infringements in sovereignty. China, of course, sovereignty remains very central to sort of Chinese visions of international law. But there's a wonderful book about how Chinese notions of sovereignty changed with respect to trade law. It wasn't easy for China to submit itself to binding third-party dispute settlement, and then to have cases brought against it, and then to lose those cases, and then to be pressed to comply with those rulings. I mean, it's actually quite remarkable in terms of traditional Chinese conceptions of sovereignty. If you think about China's response to litigation with respect to the South China Sea, and where it basically said the decision was waste paper, illegitimate, right? It never did that with respect to the WTO. And so that's quite fascinating, right? That it accepted the rulings. There was, of course, a lot of tension between different ministries in China, which one gets when one interviews. But they shifted their notion of sovereignty, that this is part of Chinese sovereignty. Why? Because the WTO legal system also protected Chinese exports, right? And that's important for Chinese sovereignty. So it shifted a sense that international organization, in this case the WTO, was actually incorporated with its conception of sovereignty within the realm of trade law, okay? That it was important. And so that's a really, for the critics of WTO, of course, this would be exactly what they feared, right? But they actually saw shifts where these countries, India, Brazil, they would actually, the idea of creating this automatic binding dispute settlement system with rules. When they joined the WTO, of course, they all said the system was rigged. The system reflected, as the previous question, US norms, US law being imposed on them. But they adapted to this system through developing legal capacity. They learned how to play it, and they saw that it was actually could serve their interests as well. And so in that sense, he saw sort of this is the paradox, right? That the US became the revisionist power, not these emerging powers, because all political science and sociology theories suggest that it's the incumbent, well, not only suggest, state that it's the incumbent power that defends the existing system. And it's the emerging powers that try to change it. And here we're witnessing exactly the opposite.
Thank you very much, Professor. Another question. The recent WTO multi-party interim appeal arrangement, MPIA, somewhat involves strange bedfellows, for example, China and the EU. How lasting do you think this kind of common stand is?
So that's a forecast for the future, which is always difficult. It's potentially lasting. The question will be, what's the future of WTO dispute settlement? So one option is we'd return to binding WTO dispute settlement system for all WTO members. A second option is that we'll have a pluralist system based on reciprocity. The MPIA is really a form of reciprocity. If you think of the International Court of Justice, you can agree to subject yourself to all disputes involving international law before the International Court of Justice, but it's always subject to reciprocity. That commitment is only binding to those who make similar commitments. And if other countries have reservations before the International Court of Justice, such as we confer jurisdiction on the ICJ except for these types of cases, right? Then that reciprocity commitment that you make is also subject to that you're not bound by any of those types of cases to the extent that the other country said that it's not bound by those types of cases. So you can look at this initiative to create an appellate appeal system as one that's reciprocity based. So those countries can join it, but they can only bring disputes against those who are members to it. You could imagine a variant of this where the United States agreed to dispute settlement with all countries except China, right? Simply, that would be its reservation. We agree to WTO dispute settlement, binding dispute settlement, and appellate process with respect to all countries, but China, that's too important for our national security, and consequently, we do not confer jurisdiction for disputes with China. That you can imagine these sort of developments taking place. We will see. I hope that a way will be found to return to a form of binding dispute settlement for all parties, but it could very well be that we're stuck with a more of a pluralist type system, which we already have for investment law, right? So that we'd also have it for trade law.
Thank you very much, Professor. Next question. Would you please elaborate on why building internal legal capacity is essential for smaller developing countries when they can hire top lawyers from overseas?
Yeah, well, first of all, if you look at the 9 different ways that trade law capacity mattered in my presentation, you can hire the top lawyers provided they provide their services on a pro bono basis, because they're very expensive, much more expensive than domestic attorneys. You can use them for actual litigation. But trade law capacity is much more important than just for litigation. It's important for negotiations. It's important for monitoring to know if you even have a dispute. So there's in the sociology of dispute settlement, there's a phrase that called naming, blaming, and claiming. That's the way it goes, naming, blaming, and claiming. First of all, you need to name. You need to say, the law has been violated. Second, you need to blame. You say, X, they have violated it. And then third, you can then bring a claim against them. But you can't bring a claim against them until you've identified the perpetrator and the violation. Outside, expensive lawyers aren't going to be doing this for you. You need to do this internally.
Thank you very much, Professor. We will just ask one more question, the fact that we do not have sufficient time. This is the last question to you, Professor. Would you please elaborate a little bit more on how the public-private relationship has worked for the emerging economic powers?
I'd refer you to this earlier book right here, which has case studies involving variation between different countries. Clearly, it's not going to shape the trading system to the same extent that the emerging powers are able to shape the system, but it provides them with more confidence, more engagement, the ability to form alliances, more meaningful alliances. I mean, they'll have to think in terms of alliances in particular, but even when you're a part of an alliance, you need internal legal capacity to determine whether or not the alliance is advancing your interests or not. Clearly, countries with large levels of impoverished people have many different priorities. And so WTO legal capacity will not be the top priority. But that doesn't mean that they cannot search for ways, including for third-party assistance, to help to develop this capacity. And so I do think it's very important. And that earlier book tries to address it. I also have an article with political scientists where we show we tie legal capacity to the impact on exports of a country into the United States as to whether or not, one, they face anti-dumping claims, and two, the amount of duties, tariffs, in terms of anti-dumping that they have to provide. And it turned out that those with lower legal capacity rankings actually faced higher anti-dumping duties domestically, outside of the international legal system completely. It's purely in terms of US anti-dumping duties than those with higher levels of trade law capacity. So trade law capacity matters not just for WTO litigation, but more broadly for trade.
Thank you very much, Professor. I wish we would have more time. However, I would want to apologize for the accidental noise on the part of the participants at the very beginning. And we certainly wish to have you more in further lectures. It was an absolute honor to have had you, Professor Shaffer. For those of you who've missed any bit of our professor's lecture, please do note that we will be uploading this particular video in our YouTube channel. Professor Gregory Shaffer, thank you very, very much, and good evening is in your side of the world.